an easy one to begin with. Let's assume that there's a trader who wants to get back into working at a market stall in a town. The COVID trader has a very particular rule which he has to follow in order to do so. The local authority says he must have taken a COVID test a day before he is due to trade and 2 weeks before that. So 2 tests a certain distance apart. And he's asked by the local authority, have you taken your tests? And he says yes. He does this in order to be able to trade and to make money. He lies. He has not taken any tests and he has not had the negative result that would be necessary. So my first question to you is, even before he starts trading, even before he does anything which would bring him into contact with other people, do you think he should be liable for an offence like fraud, lying in order to gain money? So my first question is, do you think the defendant in that scenario, the trader, is liable under an existing offence like fraud? So just have a think. Do you think there's an offence like that? And you should be getting a polling question around now saying, do you think the defendant D is liable under the current law? Do you think that's something that the criminal law today prohibits? And I'm going to give you a few moments to answer that. There's a little bit of a built-in delay when we have to ask and answer these kinds of questions. So hopefully you're having a little go at that, and I'm going to get a little bit of a signal with an answer, a percentage of how many of you think the law currently prohibits that kind of conduct, a lie to achieve some sort of property benefit before anything happens, before you've infected anybody, before you've made any money. That's the first question. Do you think the law currently prohibits that? So hopefully that process is ticking along. And while we do that, we can think about, well, okay, what would this kind of offence be? It would be an offence relating to property, about the purpose you might have to achieve some sort of monetary gain or avoid a loss. We have ways we could define an offence like that. Fraud is the most common kind of language. And it would mean you were liable even if you made no money at all before you do anything. The very saying of the lie with that purpose, under circumstances which you might say were somehow dishonest, could be enough if you wanted to criminalize this kind of behavior.
So we've had 36 responses. 81 or 83% said yes, D is liable, and 17% said no, D is not liable under the current law.
Okay, great. So that's a really good response. Let's see if we can get that even higher. But a very strong answer saying, yes, there should be liability. And actually, potentially, you're right. The law of fraud could well cover this. If you make a false representation under the Fraud Act in order to make a gain or avoid a loss, and you were dishonest, you could be liable. Now, we might then start asking, hang on, why should you be liable for that? That's the kind of idea where, why are we making this person criminally liable? Why are we imposing these kinds of consequences? And the answer could be because we think dishonesty is a bad thing, even though nothing's happened from it. Remember, nothing bad has happened. This person might never go and trade. This person might never actually make any money. But our law currently does prohibit it under the Fraud Act. So that's a neat, easy example using a lie about having had a COVID test for the purposes of a fraud offence. Okay, but most of you, I assume, aren't market traders. Great if you are, but if you're not, that example doesn't have a great deal to do with your lies. Well, let's go to something that I'm sure is really important to all of you, acrobatic yoga. So now we've got an acrobatic yoga club. People want to go and hold each other performing yoga poses, as I'm sure you know. And here the club says very clearly, you have to have a test 2 weeks before and a test the day before in order to come and perform acrobatic yoga, because we're touching each other and it's not safe to wear gloves, etc. So in this scenario, we're asking the same basic question. Do you think there could be, there is an offence under English law as it stands for someone who lies about having taken the 2 tests, saying, yes, I've taken them, yes, I'm negative, so I can come and do the acrobatic yoga. And that person then goes to the yoga. That's the idea. We haven't discussed any possibility of transmission yet. Now, if you think about that, what kind of offence would it be involved in? Now, if it was an offence relating to fraud, you'd be aiming to gain some sort of benefit in money or avoiding paying money. And that's not what we're dealing with here. This is some sort of essentially a club, a recreational activity. There isn't an offence like fraud where no harm needs to happen for that scenario. We could think about a crime like an attempt, like you're trying to achieve a result that hasn't happened yet. But it's not really clear that the person, you, me, who's going to this acrobatic yoga is actually trying to do something which would be prohibited by law. We're not saying this person's trying to infect other people with a COVID, which we don't even know this person has. So an attempt doesn't really seem like the right kind of crime either. So what we probably need here is for this person to have lied about having COVID, as in saying, I know I don't have it, I've had 2 tests, but actually does have it and knows he or she has it and is going to the club because he or she really wants to do acrobatic yoga. Now, in that kind of scenario, we're going to ask, well, the easiest case is where somebody, the partner, does contract COVID. Would there be a crime there? So we'd be asking ourselves, is that person liable for a crime like, well, causing harm or administering a poisonous or noxious substance? And COVID would probably count for that. And I think most of us would come to the view that, yes, that would be some sort of crime of causing harm to another person in that kind of circumstance. Probably a little harder is when the person just doesn't know whether he or she has it and lies about taking the test, probably thinks he or she doesn't have it, though of course knows that there is a chance. So lies about the test just in order to be able to go to the acrobatic yoga. So here's the question for you now. Do you think the defendant is liable for a crime? Let's just pick one of causing actual bodily harm. Right, that's just a crime we could pick as an example. It's under the Offence Against the Person Act, 1861, section 47, by touching in a circumstance where you've lied about being clear. So you don't know whether you have it or not, but you know there is a chance, and you've said, I do not have this disease. And then your partner the next day gets the disease, and we can trace it that you were the only point of contact where the partner could have got it from. So do you think the defendant is liable in that situation, exposing the yoga partner to a risk without knowing that you had the disease, only realizing that you might have it? So hopefully that Slido poll is up in front of your screens and you just got a moment or two to try to answer it. As I say, there's a built-in delay, which means I won't ask too many of these kinds of questions. So the question again, do you think the defendant is liable where he or she, knowing that he might have it, claims to have had 2 negative tests showing that he does not have COVID and has turned up to an acrobatic yoga session where he will hold and touch another person in circumstances where transmission is a certain level of likely, and ultimately the partner gets COVID and you're the only identifiable contact.
Okay, we're up to 37 responses this time and slightly more of a split. 76% say yes and 24% say no.
So here we're not talking about the physical transfer, which seems to be in doubt. As we say, there's no other possible causes we can identify, and that would probably persuade a jury about causation. It seems what we might be uncertain about is the fault element. You've lied in the same way as the market trader has lied, except that here we don't know whether you have it or not, just as we didn't in the market trader version. But except here, more people are a little bit uncertain because perhaps we're connecting it to the harm, perhaps because we think this is a more valuable activity than market trading, or perhaps we have different people rather than actually persuading a different number than before. So there's an interesting comparison, and the criminal law trying to protect property interests against dishonesty, and then the criminal law trying to protect personal integrity against some sort of physical harm. Well, let's keep going on this kind of example, and let's talk about dating. So now we have a date you've met on the internet, online, on an app of some kind, and you're going to meet in person, and the first requirement from your date is that you demonstrate 2 tests, 14 days before and the day before. And you say, yes, I've had those tests and I've proven negative. And again, you ask, well, how would you know that you could have the disease, even though you don't know whether you do or not? Well, I think the answer would be, in the current circumstances, the average person has a risk of receiving COVID and it being asymptomatic. There's a very high chance of being asymptomatic. So unless you've been isolated pretty much for the whole time, I think the average person scientifically would accept that there is a chance they have it. So I think in the current circumstances, it's not difficult to say somebody has, someone knows that they might have an infection where there's strong asymptomatic qualities to it. As a matter of evidence and proof, I think a court would probably accept that. If you wanted to prove that the other person had received it from you, that's a lot more difficult. And that's why I isolated the second person in that example. So anyway, we're back to the dating example. And again, 2 weeks before and the day before. And here, we're only going to talk about a kiss, a smooch, a snog, right? So here we're talking about not physical harm per se, not necessarily. What we're talking about is the right that someone has to choose their own autonomy about dating. In this case, we'd use the word sexual, even though we're not yet talking about actual sex. So someone chooses who they get to kiss. Now, is this a different kind of interest that the criminal law might protect compared to first the property example and second the mere physical contact example? Do we want to protect the interest that we have to determine our own sexual activity higher, lower, the same as we would property, as we would personal integrity? So here's my question for you. Do you think the defendant should be liable for a crime? And the crime I'll give you would be sexual assault. This is touching another without consent, without a reasonable belief in consent, and on the basis of lying about having a negative pair of tests for COVID, whereas in fact, you haven't had any tests and you don't know if you have it. So that's a question that should be coming up for you. Do you think the defendant is liable here for what I'm telling you is sexual assault? This is a Sexual Offences Act 2003, Section 3, touching another person in a sexual way, which includes kissing in this example, where there is no consent and where you don't reasonably believe in consent, because you have lied that you've had negative tests for COVID, whereas actually you haven't had the negative tests and there is a chance you have it and that therefore you could pass it on. And as you probably know, kissing is one of the most likely ways to pass it on, even more likely than acrobatic yoga. So hopefully a few of you are feeling, maybe we can reach 38. Oh, the dizzying heights. Maybe we can meet at least 38 people filling this in. And let's see what you think. Do you think sexual assault it would have been met on these facts? So notice also that I'm giving you slightly more detail about the offences as we go on, starting from there might be an offence of to actually giving you the words that the statute uses. So what kinds of numbers are we looking at? Do you think the defendant is liable? Okay, so we're up to 40 responses, dizzying heights indeed, and 80% say yes and 20% say no. So this is really interesting. We're hovering around lots of liability around the 80% mark for people, and we're saying there is sexual assault. Now, why is there sexual assault? Now, what is this about? Again, we know the interest is in sexual integrity, right? The autonomy to choose who you engage in sexual activity with. And this would mean then that something about the lie about the positive tests, sorry, that you've had negative tests, is so powerful that it removes the consent to otherwise an act of kissing. So we'd be saying something along the lines of, there appeared to be consent to kissing, fine. But that consent didn't really apply because of the earlier lie that you made about having had the negative tests. And that's interesting. We could take it to an even more extreme example, and we can play around outside of COVID, and we'll see if those numbers change. as you know, there are many sexually transmitted diseases. And we could assume, if we take it further, that the question was not, have you had 2 negative tests for COVID, which would be a very strange, I mean, understandable, but a weird dating environment to be in. Let's take it even further, and there is a sexually transmitted disease, disease X. And the 2 people going on a date, they actually have sexual intercourse. And beforehand, the partner, the complainant, as we would say, says, have you got disease X? And the other person says, no, I don't have it, not knowing whether it was true. In this case, let's say he had it or not. So he doesn't know, but he says, no, I don't have it. Is this intrinsically any different to the COVID example? Well, all we've changed so far is the lie being very specific about 2 negative tests, and his description here being a bit vaguer, saying, well, no, I don't have it. Not that, no, I have had 2 negative tests. So I'm not sure anything significant has changed. So I'm going to assume for the moment that your answer would be exactly the same. In that scenario, actually, the criminal law probably doesn't say that there was rape. And we had a case at the end, in the middle of the summer, saying something very similar to that example. Now, this was actually a case about fertility, about a man who said, I have had a vasectomy, so I no longer produce sperm. Well, at least I no longer would send sperm during sex, because the woman said, I'll only have unprotected sex if you've had a vasectomy. And he said, I've had a vasectomy. And they have sex. And the next day he sends a text message and says, I'm sorry, I have a confession to make. I haven't had the vasectomy. I'm still fertile. And is that rape? So notice we're dealing with a lie again. We're dealing with a deception. And the question is that still what the complainant consented to? So let me ask you this question. Do you think the defendant is liable where he lies about his fertility? So is he liable for, let's call it rape, which we will just for the present purposes say is sex without consent and without a reasonable belief in consent, where he lies about his fertility. He says he is infertile, and therefore the complainant consents to unprotected sex because she's very clear she doesn't want to get pregnant. Hopefully that question is coming up for you now. Do you think the defendant is liable? So we've taken the example a little bit further, and we've stepped outside of COVID, and we've taken to a recent Court of Appeal decision on this very issue. So what do you think? Do you think the current law currently says the defendant is liable in this kind of situation? A lie about fertility before unprotected sex. No, I'm infertile. Okay, then let's have unprotected sex. And then in actual fact, on the facts of this case, the woman did get pregnant and had a termination because she was very clear she didn't want to get pregnant beforehand and carried that out afterwards.
Okay, we're up to 40 responses again already. 85% say yes, 15% say no.
Okay. So now let's pause for a moment. You've decided what you say the law is. Now we're going to ask a slightly different question this time and say, what do you think the law should be? So we were saying this is what it is. This is descriptively what we think the answer is. But remember, it's really, really important that you can make decisions about what the law should be. There's loads of areas of the criminal law I passionately disagree with. I think they're wrong. And there's plenty of areas which I think are doing a pretty good job. So what do we think the law should be here? Do the 80-odd% who think the law is criminalizing here, do they think it's correct? Or would you rather think there should be a different rule? So the question I'm asking you now is, do you think the defendant should be liable in this scenario? Not what the law currently says, but if you were to describe or define your own ideal legal system, in this scenario, with the defendant who lies about his fertility, saying, I am infertile, when in fact he's as fertile as he was earlier in his life, be liable when thereby there is unprotected sex, whereas there would not have been unprotected sex if he had told the truth. Is he liable for rape? Sorry, should he be liable for rape? That's the question. Should he be? So while you're filling out that question, let me just talk around this issue a tiny bit more. So one possibility here is you say, well, this is never the act that she consented to. She consented to only an act where there was no chance of pregnancy. And what actually happened was an act where there was evidently a significant chance of pregnancy. Another way of looking at it is she consented to sex on condition that there was no significant risk of pregnancy, and that condition was broken by his lie. Both are slightly different ways of looking at the same kind of issue. Now, another way to respond to that would be to say, no, unprotected sex carries risks. If you consent to unprotected sex, you can't then complain that one of these risks comes about. So that's another way of responding to this idea. No, you consented to sex. And what you could argue is instead, it wouldn't be a sexual issue that you're complaining of. You could be complaining of some sort of physical injury. So if we skip back to a sexually transmitted disease X, if sexually transmitted disease X is quite a serious injury, you could prosecute the person who lies saying, I don't have it, when he or she doesn't know, for some sort of grievous bodily harm if they transfer it to you. But it wouldn't be sex, goes this argument. This argument would be along the lines of, well, sexual integrity involves choices. It involves choices which compose of risk. And you made the choice to accept the possibility of a disease when you accepted unprotected sex. How are we looking at the slide?
Okay, so this time we have 50 responses. 51. 82% say yes and 18% say no.
I see. Okay, so I guess you want me to tell you the answer from the Court of Appeal decision. So this was a case called Lawrence, and it is exactly these facts about a man who lies about fertility. He says he's infertile, he was not infertile, and the Court of Appeal decided that he was not liable for rape. They essentially say that there are risks and that she consented to sex, and the sex she consented to was the sex that she had. I am in no way saying I agree with this decision. I'm simply telling you what the Court of Appeal decided. And we have earlier case law, and in a way, if you confine yourself to the scope of the two groups of decisions we already had, you might see why this was a tough decision. And often law comes down to this. You've got one group of case law and another group of case law. You've got to decide where your new case fits in. So the first group of case law was about infectious diseases. And the court has decided, going back to the 1880s, that it wouldn't be rape in those circumstances. We then decided in the early 2000s that it could be a grievous bodily harm example. So for instance, HIV now statistically is incredibly unlikely to be transferred through sex because almost everybody who has HIV knows they have it, and almost all of those are seeking treatment. And when you seek treatment, the viral load is so small it's not transferred. But if we ignore that for just a moment, and we say a man who knew he had it, wasn't seeking treatment, and ends up transferring it to somebody, couldn't be liable for rape, because the court said very simply, very shortly, the complainant consented to sex. Now, actually, the chance of receiving HIV from somebody who knows they have it and knows they aren't seeking treatment, compared to somebody who, the average person in the population, so the chance that a person has it, the chance that person hasn't been identified, or because if they're identified, they're almost all seeking treatment, is nearly 6,000 times greater. So there's a very big difference in that risk profile. But the court didn't engage with that kind of issue. And they said, so if we're talking about a disease, if we regard sperm, the possibility of creating a child, as a disease, we would say that you consented to the risk during sex. That's the case law we have. Whereas we have cases along the lines of condom usage. So if you agree to wear a condom and for some reason you don't, you take it off, whatever the story is, you deliberately don't wear it, that would be rape. So that's a very difficult line between, once you agree to something that's unprotected, effectively you're taking all the risks, the court says. You can't put any conditions other than a condom or similar, which would be effective. Whereas on the other hand, if it's a condition about wearing a condom or in some way not completing the process, then it would be rape. So we always know that these methods are imperfect. Condom usage is not 100% effective. vasectomies can undo themselves over time. I think if the question was, I lie and say, the defendant lies and says he's had a vasectomy, there's always the knowledge that it could undo. And there is that tiny chance. I don't know what those numbers are off the top of my head, but there is always the possibility that it could be undone. But if you turn the question on the characteristic, have you had the vasectomy, and if that's the question, then there is inherently some risk in the vasectomy, just like there is inherently in the condom too. And you might also start asking, well, what about the purpose of consent? What are we actually testing for? And in many areas, a voluntary decision in law is talked about as one that's free, informed, and deliberate. So there's no conditions on it. You're not threatened. You have the information you need, and you've had the time, opportunity, and ability to think about it. And we might earlier talk about capacity, but we won't engage in that right now. Actually, the Sexual Offences Act, section 74, only talks about a choice and the freedom and capacity to make that choice. So it doesn't actually openly talk about information and deliberateness of the decision making. Now, sometimes we've attempted to fit that kind of idea of being deceived into the idea of your freedom to make the choice has been removed. So that's one way we can try to bring in these fuller ideas. But ultimately, we don't have a test for it in the sexual offences, which is as good as we might have liked it. And that's probably why you could be liable for an offence against the person, like causing grievous bodily harm. But the old law says, currently the current law says, you're not liable for a sexual offence, because they use slightly different definitions of consent. And again, there's risks in all of this conduct, right? There's contraceptive pills, whether taken by, typically it's taken by a woman in this scenario, assuming we're talking about heterosexual activity, but assuming there was one for a man, and he knows he hasn't taken it that day, assuming it's a daily pill, that would be a very difficult decision, depending on your analysis of the role of consent. The current law would say, well, that's no problem, because all of it would still be valid sex. But if you do take the view, as I think some do, that this would be rape because there was a lie about something essential to her decision-making process, and she wouldn't have consented had she known, then you might take the view that, that the failure to take the sperm control pill would be rape. As I say, the current law might not take that position. Is there a fundamental difference here with describing somebody as a rapist because they knew there was a condition which they did not fulfill, but they lied and said they did fulfill? Is that different compared to someone using force, for instance? And I guess that really turns up on what we think rape is. And I don't want to get into the details of this given the time we have and the medium we're in, but you could start asking, well, do I have this idea in my head that rape must involve force? Is that the paradigm for me? Is that the example of what the rape idea is? And if so, why? Is deception fundamentally different? Is it worse? Is taking away someone's own ability to choose? If you were walking down the street and someone grabs your purse or bag or wallet and runs off with it, you'd feel violated that your physical integrity had been interfered with. If somebody comes along dressed as a police officer and says, I really need to see that, and tricks you out of it, and then runs off, do you feel better or worse, or do you feel the same? I mean, are your interests protected in the same way? So I don't have an answer to you. I personally don't have a problem with the law relating to sexual offences not to require force at all. I think that's a very sensible route. How do we decide any of this? Well, ultimately, any law analysis is going to have to be based on things like, first off, what are the general principles we're trying to protect? What's the purpose of the law? And I tried to walk you through some issues relating to property protections, personal integrity protections, and sexual autonomy protections as different things, potentially different places the law might choose to intervene and how they might intervene. And I've also tried to show how different comparisons might be made across those examples, because the law at the same time might have, or needs to be coherent and consistent. People have to be able to understand it and live their lives by it fairly without having uncertainty, or at least not too much uncertainty, about how not to become criminals. So when I look at the Court of Appeal's decision in the case I was just talking to you about, Lawrence, Personally, I find it probably incorrect to err on the side of a sexually transmitted disease as opposed to the condom usage. But part of that for me is the underlying assumptions about what it is to have unprotected sex, that you just cannot control the risk at all. The only risks you can control are basically whether there is any form of protection which the court recognizes. I personally don't find that persuasive. And that's why I personally am bringing in comparisons and trying to say this is my fair judgment about what the law should be. But to do this properly, you've got to get into what the relevant text says, what the earlier the statute, the Sexual Offences Act, what the earlier case law says, and you've got to be able to go through it very carefully and provide the arguments you want. One other element to this is the court was in a relatively difficult position, as I've said, because these two cases were relatively close to each other. And it was trying to find a general test to help cases going forward, because for every case that comes to court, there's hundreds, thousands, which are waiting to find out what the answer is here. Not every interesting issue always manages to get to court. They're decided in a penumbra, in a sort of a shadow area where we're trying to work out what the rule is, because we can't take every case to court. That's particularly the case now because of backlogs created by COVID. But as you may have been reading, we had a 37,000 case backlog in the criminal courts before March, and now we have 43,000. So COVID has only added 6,000 onto the 37,000 we already had. Our criminal justice system is in a lot of strain, which makes it even harder to get both the first instance decisions and then later to get the Court of Appeal decisions, and maybe even Supreme Court after that, but they hear very few criminal cases. So what I've been trying to do is walk you through a few examples of what it's like to try to reason through criminal law. I've got about 5 minutes left, a little less, in case you guys had any questions you wanted to ask me about anything else. So do please write on Slido and other things if you have any questions, if I can try to answer them for you. I'm going to keep talking in the meantime, and hopefully questions will pop up. So you've got lots of other things to do in this open day. You'll get to meet some really amazing colleagues of mine, both from the staff side and the academic staff side. There'll be lots of opportunities to meet students and other people. I know it's not the same thing as getting to meet you in person. I'm sorry about that. It's really great to get to meet you guys on open day events, and it's just the best we can do in these circumstances. I can't tell you what it's like to study here quite up front. What I can tell you is it's an amazing opportunity for people who really do want to think about difficult issues like this, who want to bring in lots of skills and talents and try to advance their own brains to try and think through things better. But it is hard work. And the only way you can get in is if you apply. That's the simplest rule. And we'll then have to do a lot of sorting. And we can't let everyone in who we want to. We would love to work with so many of you, but our places are scarce. I hope you've got the impression that we are only looking at your potential as the selection criteria on our website. We're not interested in other things, race, color, creed, background, except to the extent they might have disadvantaged you, and we want to try and make allowance for that to judge you properly as a candidate compared to the others. But it doesn't matter your background, and everybody is very welcome. A couple of questions. Is this similar to the experience we've had an interview? Maybe if it was online, yeah, I can imagine how that would be more so. If it was an interview, you'd be doing a lot more talking. We would ask you questions to see how you think, and that's not something I can do in this format quite as clearly. In a tutorial, which an interview is in a sense a sort of a prelude to, it would be more talking by you again, and you would have to have a greater mastery of these cases. One of my students is on as one of the helpers, and she is, loving this because it reminds her very much of her criminal law tutorials. What are your thoughts on the recent decision in Barton regarding dishonesty test? Right then, well, that's a pretty specific question. The law on dishonesty changed when the Supreme Court, in a civil case called Ivey and Genting, decided to change the law in criminal law, and that's unusual. In fact, it's very, very unusual. And the Court of Appeal very recently decided that yes, the Supreme Court did change criminal law while changing civil law. It was also not necessary for the determination of the civil case. So it was already something that wasn't necessary in the civil case and being applied in the criminal case. So Barton didn't surprise me, and that the Court of Appeal did that. I think there's some very difficult issues about how legal precedent works, about how one court binds a lower court when there was no argument in the Supreme Court on the criminal law, and it was largely because a senior judge, now retired, felt very strongly that the criminal test was not a good test. Now, he might be right or wrong, but there's issues of procedure about how we can best get to the right answer. And generally speaking, our legal system says two roughly equally armed sides fighting, each presenting their argument about the best answer, enables the central party, the judge or judges, to come up with the closest approximation of truth about the best answer for a legal test and for facts that we can come up with. And if you accept that as a premise, you would also have to accept people needing legal defense, even when you think they're guilty and even when they're poor. And in which case, yeah, you might start asking difficult questions about how best we can achieve that. Yes, lack of evidence is a very significant problem for us. So many crimes don't get reported. So many crimes are very difficult to prove. There's some evidence that when we talk about deterrence, it's something people who want our system to become even harsher, and it's already very, very harsh. They talk about, well, you've got to deter people from committing crime. Well, the best deterrence is actually certainty of arrest. If you knew every time you speeded in a car, you would get a penalty, you wouldn't speed. It doesn't matter if the penalty is small, it will still add up. Whereas to do it the other way around, you need a really, really, really harsh penalty to stop people doing things if they think there's only a 1 in 10, 1 in 100 chance they're going to get caught. I've got one last question, which we're really running out of time. What type of cases do you think one should read to get a feel for law studies, and where does one go to find these cases to read? Okay, that's difficult. And there's some great blogs out there, and they provide some information, things like Public Law for Everyone. There's a bunch of them. There's a good books like What About Law? That gives you introduction to some of the major topic areas and introduces some cases. But all of the cases are on, well, almost all modern cases are on bailii.org. So BAILII.org, the British and Irish Legal Information Institute, which contains all modern cases. You could follow up on ones you see on the news or in the Times law section. There's other places like that. Basically really read facts and think, now what do I think should be the answer before you then read the analysis. Really challenge to get your own ideas first. Otherwise you can easily be led by the biases of the person giving you an instruction. So anyway, I'm afraid, I'm really sorry, we've tended to have reached the end of the time we have now. And I know you've got a busy day. There's lots of other things you're going to have to do. I just want to say from our perspective, we are really looking forward to getting to work with talented students. We know the system is daunting, and we're just doing our best to try to make sure the candidates with the most potential get through. And I really hope you learn a lot from this open day. Thank you ever so much for your